All right. Good morning, or I guess now good afternoon to our guests and colleagues joining us for today's CLE. I see folks are coming into the webinar a pace. It seems like we're leveling off here. So we will go ahead and get started. Well, good afternoon. On behalf of the Law School's Board of Advisors and the Academic Engagement Committee, let me welcome you to today's CLE offering from Minnesota Law. My name is Devin Driscoll. I'm a member of the Board of Advisors and a member of the committee, also a graduate of the class of 2018 from Minnesota Law. Today's CLE topic will address the landmark SFAA, Students for Fair Admissions, versus Harvard and the University of North Carolina decisions, and the current potential future impact of those cases. My fellow board member and law school alumna Emerald Gratz, in the class of 2005, who is an Associate General Counsel at the Minnesota Department of Public Safety, will help to moderate today's discussion. Just a couple of housekeeping notes. Today's webinar is being recorded, and the link and recording will be shared via email following the event. We also have live auto captioning enabled. You can click on the live transcript feature at the bottom of your Zoom screen to view or hide these captions throughout today's discussion. We will do our best to reserve time at the end to pose questions submitted via the Q&A feature also found on the bottom of your Zoom screen. And with that, let's meet our panelists. First, I'm pleased to introduce Professor Jill Hasday. Professor Hasday teaches and writes about anti-discrimination law, constitutional law, family law, and legal history. She's written 2 books, Family Law Reimagined in 2014, and the award-winning Intimate Lies in the Law in 2019. Professor Hasday's articles have appeared in many leading law reviews, including, to begin with, Minnesota Law Review. In addition, Harvard Law Review, Stanford Law Review, New York University Law Review, Michigan Law Review, almost left them off, California Law Review, Georgetown Law Journal, UCLA Law Review, Vanderbilt Law Review, to name a few. Professor Hasday has her BA from Yale University and her JD from Yale Law School. After law school, Professor Hasday clerked for Judge Patricia Wald of the United States Court of Appeals for the DC Circuit. She's been a tenured member of the faculty at Minnesota Law since 2005 and has been Centennial Professor of Law since 2013. In 2014, Professor Hasday became a distinguished McKnight University professor. Welcome, Professor Hasday. In addition, I'm pleased to introduce Carrie Ryan Gallia. She's a Senior Associate General Counsel at the University of Minnesota Office of General Counsel. She's been there since 2016 and practices litigation. Prior to joining OGC at the University of Minnesota, Carrie was an attorney at Lindquist and Venom, and before that at Fish and Richardson, both here in Minneapolis. She graduated magna cum laude from Princeton University with a degree in English literature, and then earned an MFA in dramaturgy at the Columbia University School of Arts. In 2008, Carrie received her JD summa cum laude from the University of Minnesota Law School, where she served as a managing editor of Minnesota Law Review. Was a member of the Order of the Coif and won the William B. Lockhart Award for Excellence in Scholarship, Leadership, and Service. After law school, Carrie served as a law clerk to Judge Carlos T. Bay on the U.S. Court of Appeals for the Ninth Circuit. And so to our panelists, thank you very much for your time and sharing your expertise with us today. And I'll turn it over to my co-host, Emerald.
Thank you very much, Devin. We are so excited on behalf of the Board of Advisors and the Academic and Engagement Committee to have such a robust audience today. We had more than 200 people register for this webinar. So without further ado, my role today is merely to take any questions that are put into either the question and answer function or in the webinar chat function and pose them to our panelists as we're able to. But otherwise, we are just going to let Professor Hasday and Carrie give this very interesting presentation. So Professor Hasday is going to start us off talking about the legal landscape before the SFAA versus Harvard decision and then the decision itself.
Okay, thanks so much for having me. I'm delighted to be here. As Emerald said, I'm going to talk about the constitutional law of affirmative action placing the Supreme Court's decision in the context of what came before and what might come after. I'll start far back in American history. Before the Civil War, there was no constitutional provision designed to combat or limit race discrimination. Race discrimination and legalized white supremacy were pervasive. Slavery was the most virulent manifestation, but even free people of color were legally and routinely discriminated against in every area of life. After the Civil War, Congress proposed and the states ratified 3 new amendments known collectively as the Reconstruction Amendments. The 13th Amendment prohibited slavery. The 15th Amendment prohibited race-based denials of the vote, although that was flagrantly ignored for a century. Today, I'm going to focus attention on the 14th Amendment to the Constitution, which was ratified in 1868. In particular, the Equal Protection Clause of the 14th Amendment prohibits any state from denying, and this is a quote, to any person within its jurisdiction, the equal protection of the laws. In the first decades after the 14th Amendment's ratification, the Supreme Court was not interested in interpreting the Equal Protection Clause in a way that would combat racial injustice and fight race discrimination. Most notoriously, in an 1896 case called Plessy v. Ferguson, the court held that racial segregation in public transportation was constitutional so long as the segregation was supposedly separate but equal. The Plessy decision allowed states, especially but not exclusively in the South, to institutionalize a system known as Jim Crow segregation, which racially segregated every area of life, including not just transportation, but also schools, courthouses, and places of public amusement like movie theaters. Under Jim Crow, for example, states explicitly reserved some public schools for whites and other public schools always with fewer resources for children of color. The NAACP began a highly organized litigation campaign in the 1930s, challenging the constitutionality of Jim Crow segregation under the 14th Amendment's Equal Protection Clause. This campaign won a series of victories that made defending the constitutionality of Jim Crow increasingly difficult. And finally, the court held in a 1954 case called Brown v. Board of Education that laws requiring racial segregation in public schooling always violate the Equal Protection Clause. Over the next 15 or so years, the court relied on Brown to strike down other aspects of Jim Crow segregation so that transportation, public parks, and other aspects of public life were no longer officially segregated by race. These decisions did not eliminate all racial disparities. In fact, they didn't even eliminate public schools that, as a practical matter, had students of only one race. But they did succeed in eliminating virtually all forms of government action that drew explicit and open distinctions based on race. During these years, the Supreme Court took for granted that the 14th Amendment's Equal Protection Clause was designed to protect people of color from race discrimination. The court did not consider or suggest the possibility that measures designed to undo the effects of past and present race discrimination might themselves raise constitutional problems under the Equal Protection Clause. Affirmative action programs were first introduced in significant numbers in the late 1960s and early 1970s to expand opportunities available to people of color. Over time, critics of affirmative action increasingly argued that these programs were themselves unconstitutional because they treated people differently based on their race. The court first explored the constitutionality of race-based government affirmative action in a 1978 case called Bakke, Regents of the University of California v. Bakke. This case focused on the constitutionality of an affirmative action program at the University of California Davis Medical School. That program reserved 16 spaces out of an entering class of 100 for students of color. Members of racial and ethnic minorities weren't limited to those 16 spaces, but basically white applicants could not apply for those 16 seats. The court was deeply divided in Bakke. 4 justices thought the medical school's admissions program was constitutional and basically saw no constitutional problem with affirmative action. 4 justices thought the medical school's program was unconstitutional and that affirmative action taking race into account was always unconstitutional. And Justice Powell was in the middle. He thought the medical school's admissions program was unconstitutional, but he also thought that there were other versions of affirmative action taking race into account that would be constitutional. Powell's opinion proved to be the lasting legacy of Bakke, the part of the case to which all later judicial opinions refer. Powell's argument had a few steps. First, Powell argued that courts should be equally skeptical whenever a government explicitly classifies based on race. In other words, Powell thought the court should apply the same level of skepticism to a Jim Crow law saying this water fountain is for whites only, that it would apply to an affirmative action program taking race into account. Powell thought the medical school's 16-seat set-aside couldn't survive this level of scrutiny. Why? Basically, he thought the medical school was simply helping people of color at the expense of whites. Powell thought that was constitutionally impermissible and feared such an approach would promote racial animosity. So that was his argument for why the medical school's program was unconstitutional, but he didn't stop there. After explaining why he thought what the medical school had done was unconstitutional, he went on to say he thought a different kind of affirmative action, taking race into account, would be constitutional. Specifically, Powell thought that public universities could adopt affirmative action programs designed to further their interest in diversity, so long as the universities valued many types of diversity beyond racial diversity and treated diversity as a flexible plus factor where all applicants remained in competition for all admission slots. Remember, though, Powell was only writing for himself in Bakke and presenting his own ideas about what public universities should do. The immediate result in Bakke is just the court strikes down the Davis Medical School's 16-seat set-aside program. After Bakke, the court took a series of cases on affirmative action in the 1980s and 90s. I won't discuss each one, but I'll summarize them this way. Each case struck down whatever government affirmative action program the court was reviewing. In fact, there was no affirmative action program from the government that the court reviewed in the 20th century and found constitutional. Why were all these programs struck down? In each of these cases in the 80s and 90s, the court echoed the argument that Powell had made in Bakke, that the justices should be just as skeptical of affirmative action taking race into account as they would be of a Jim Crow segregation law. The government's defending affirmative action told the justice, even if you are skeptical of affirmative action, our programs can survive that skepticism because we have really important interests at stake. For instance, we're trying to counter historical and ongoing discrimination, or for instance, in the case of public schools, we're trying to promote, and public school teaching, we're trying to promote role modeling. But the court rejected those arguments, holding in the 80s and 90s that the federal government and the states do not have a compelling interest in remedying societal discrimination or in promoting role modeling. Moreover, the court in the 80s and 90s introduced a new argument against affirmative action that had not been visible in Powell's Bakke opinion. Just as Powell had been openly concerned about the idea that affirmative action harmed what he called innocent whites, meaning applicants who had never been personally found guilty of race discrimination but could not compete for these 16 slots. In the 80s and 90s, the Supreme Court emphasized a new argument against affirmative action, insisting that an even bigger problem with affirmative action programs was that they harm people of color who were the purported beneficiaries of those programs. Justice Clarence Thomas, who joined the court in 1991, was particularly interested in making that argument. Echoing what critics of affirmative action have been saying in popular media, Thomas contended that affirmative action was stigmatizing and that people of color would be better off without it, even if they didn't realize it. Okay, so let's turn to the start of the new millennium. After the series of cases in the 80s and 90s, many people wondered whether the court would ever find a race-based affirmative action program constitutional. It finally did in a 2003 case called Grutter v. Bollinger, which upheld the constitutionality of the affirmative action plan at the University of Michigan Law School. Remember when I said the court decided it would apply the same level of skepticism to affirmative action that it would apply to a Jim Crow law? I'm going to break that down more specifically now. The Supreme Court subjects any government action that explicitly distinguishes based on race to a form of review known as strict scrutiny. This is the most rigorous review the court ever applies to anything. It's exceedingly difficult for a government policy to survive that review. Strict scrutiny has two components. For a government policy that makes explicit race-based distinctions to be constitutional, it must first serve a compelling government interest, and second, be narrowly tailored to promote that interest. By the time of the Grutter case, the court had already decided that remedying societal discrimination, promoting role modeling, did not count as compelling government interests sufficient to survive strict scrutiny. In Grutter, however, a majority of the court accepted the proposal that Justice Powell had put forth decades earlier in his separate opinion in Bakke, namely that diversity could count as a compelling government interest. To date, promoting diversity in public higher education is essentially the only government interest the court has accepted as a compelling government interest. The Grutter court also agreed with Powell that for a government affirmative action program to be narrowly tailored to serve this compelling interest in diversity, the university had to consider many different kinds of diversity in addition to just racial and ethnic diversity, had to treat each student individually, and had to treat diversity as a plus factor rather than an automatic grounds for admission or exclusion. The Grutter court also held that narrow tailoring requires the university to constantly review its program. Affirmative action programs can't just run indefinitely. The university must be continually assessing whether it's still needed. In fact, the Grutter court appeared to express the view in 2003 that affirmative action would no longer be necessary within 25 years, meaning 2028. I'll just quote what the court said in Grutter because it was quoted a lot more recently. So this is what the court said in Grutter when it's setting out this 25-year time horizon. We take the law school at its word that it would like nothing better than to find a race-neutral admissions formula, and will terminate its race-conscious admissions program as soon as practicable. It has been 25 years since Justice Powell first approved the use of race to further an interest in student body diversity in the context of public higher education. Since that time, the number of minority applicants with high grades and test scores has indeed increased. We expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today. Okay, so that's what Grutter says. Before moving on, I'll just make a few comments about Grutter. First, the court was simultaneously upholding the constitutionality of race-based affirmative action and expressing misgivings about the practice. Usually, when a court issues a constitutional opinion, it does not simultaneously predict that future justices will be reversing course in 25 years. Usually, they write as if this is going to be the rule for all time. Second, I want to return to the court's acceptance of the idea that public universities have a compelling interest in promoting diversity, after the court had previously rejected the idea that the government has a compelling interest in remedying societal discrimination. It's hard to say for sure why the court found the diversity argument more compelling or convincing than the societal discrimination argument, but it is notable that recognizing a government interest in diversity says nothing about America's history or continuing practice of race discrimination. It's an ahistorical argument that just argues that diversity and affirmative action benefit everyone. Framing affirmative action as a tool for promoting diversity also makes it much easier to attach a short timeline to the practice, which might sound less plausible if the purpose of affirmative action was described as countering more than 4 centuries of legalized race discrimination. Third, the court in Grutter was accepting a version of affirmative action that required significant resources to carry out, so all applicants could be considered individually and flexibly. On the same day that the court upheld the affirmative action plan at the Michigan Law School, it struck down the undergraduate affirmative action plan for University of Michigan undergrads. The court held that the University of Michigan undergraduate plan was not narrowly tailored because the undergraduate program basically just gave applicants an extra 20 points on the 100 you need to win admission if you were a member of an underrepresented racial or ethnic group. Race and ethnicity wasn't the only way to get an extra 20 points. You get extra 20 points for being an athlete or playing the tuba or something, but you got those automatic 20 points. The court said that that was not sufficiently narrowly tailored because it wasn't individualized enough. Why did the undergraduate program seek out this method rather than just copying the more individualized and flexible approach to the law school? Because the undergraduates simply had many more applications and they were trying for something that would be a little more efficient. Striking down the undergraduate program meant that for universities who wanted to continue to have affirmative action after Grutter, they had to have a highly individualized method that was very resource intensive. Okay, that's just context. Let's move on now to the 2 cases the court decided in June. One a challenge to affirmative action at the University of North Carolina, and the other a challenge to affirmative action at Harvard. The court issued its decisions in these 2 cases in a combined opinion entitled Students for Fair Admissions versus President and Fellows of Harvard College. Students for Fair Admissions, or SFAA, did not officially overrule Grutter. Perhaps, I think, because the court was wary of officially overruling a major precedent after all the headlines generated around the world when Dobbs officially overruled Roe. Instead, Students for Fair Admission hollows out Grutter from the inside. Remember that Grutter held that diversity in public higher education constitutes a compelling government interest? Students for Fair Admission doesn't explicitly reverse that. Instead, the new decision argues that judges can't determine whether an affirmative action policy that takes race into account advances compelling government interests, because goals like training future leaders or acquiring new knowledge based on diverse outlooks are too amorphous for judges to assess whether they've been achieved. So Students for Fair Admission doesn't say diversity is a bad goal. It just says it's not a goal you can rely on in court because courts can't assess whether it's being furthered. Students for Fair Admission also held that affirmative action programs that give applicants a boost for being a member of an underrepresented racial or ethnic group fail narrow tailoring, and here the court presented a number of arguments. One was that the racial categories the universities were using, which basically came for the census, were overbroad or under-inclusive because, for instance, they didn't distinguish from people from different parts of Asia and didn't adequately define what Hispanic means. The court also picked up on the 25-year time horizon language from Grutter and argued that race-conscious affirmative action plans fail narrow tailoring because they lack a definite endpoint. The majority argued that continuing these programs until diversity is achieved doesn't work because, again, the court can't assess when diversity is achieved. So that basically just means the court said these programs can run forever. In addition, the majority argued that race-conscious affirmative action plans fail narrow tailoring because they disadvantage white and Asian applicants because of their race. Here, the court was really rejecting a central argument that Powell had made in Bakke. Powell's basic argument was that affirmative action of the kind he liked, meaning all sorts of different kinds of diversity, everyone's in competition for every spot, helps everyone. It produces a more diverse class with bigger, just a bigger range of perspectives. The court in SFAA rejects that and says affirmative action is a zero-sum game. Giving members of underrepresented racial ethnic minorities a boost for being in those groups means giving a negative to people who don't get those boosts. Okay. I just want to say a quick word about some implications because I know Carrie is going to focus on how universities have responded. First, what universities are governed by SFAA? It's important to say at the outset that affirmative action admissions programs have always been limited to highly selective colleges and universities. Most colleges and universities admit everyone who meets basic requirements, so affirmative action isn't an issue. What Students for Fair Admissions means is that selective colleges and universities cannot give applicants a plus in the admissions process for being members of underrepresented racial or ethnic groups. Moreover, that prohibition applies to public as well as private universities. Public universities like University of Minnesota or University of North Carolina are governed directly by the court's interpretation of the 14th Amendment of the Constitution. Harvard and other private universities that receive public funding, which is essentially almost every private university, are governed by Title VI of the 1964 Civil Rights Act. That statute prohibits institutions that receive federal funding from practicing race discrimination. In the same decision where the court held that UNC's affirmative action program violated the 14th Amendment of the Constitution, the court held that Harvard's affirmative action program violated Title VI of the 1964 Civil Rights Act. In other words, the court held that Title VI's prohibition on race discrimination means the same thing as the Equal Protection Clause's prohibition on race discrimination. Giving applicants a plus in a university or college admissions process because of their race or ethnicity is not allowed in either context. The only exception at the moment is for service academies like West Point. The majority included a footnote explicitly saying that the court was not addressing the issue of affirmative action in military academies because, quote, in light of the potentially distinct interests that military academies may present. The people behind this, the SFA suit have already sued West Point challenging affirmative action. So time will tell what happened there. But at the moment, the military academies can still use affirmative action. I know Carrie's going to talk about what universities can do under this program. So I'll just mention one last set of potential implications of the decision before turning to her. Students for Fair Admission is focused on affirmative action in the context of university admissions. But now that the court has held that race-conscious affirmative action in the admissions context is nothing more than race discrimination, full stop, the court may extend that same reasoning to other contexts. So, for instance, Title VII of the 1964 Civil Rights Act prohibits race discrimination in employment, and that's both public and private employment. I suspect that I don't like to predict the future because I'm often wrong, but if I had to predict, I would say the court is going to apply the same idea in the Title VII context and say affirmative action that takes the form of giving someone a boost for being a member of an underrepresented racial ethnic group also violates Title VII. Okay, so I'm going to turn it over to Carrie, who I know wants to talk about what universities can and have been doing in light of SFAA.
Great, thanks, Jill, so much. I'm very happy to be here with everyone today. So this decision in SFAA was issued by the Supreme Court on June 29th, 2023. And as soon as the decision issued, it became law. At the University of Minnesota, we were issuing admissions decisions that very day. So there were still transfer applicants being considered and waitlisted students were still being considered. So there was no opportunity for us to sort of deeply digest and take months to figure out what to do because we were still taking steps to comprise the class that would start in the fall of this last year. So we had to look to the decision for guidance. And then we also heard from the Biden administration, which shortly after the decision came out, promised guidance in about 45 days. Again, we had decisions going out that day, so we didn't really have 45 days to wait. So colleges and universities universally looked to a section at the end of the opinion for guidance on how to implement the court ruling going forward. And I'm going to read from Chief Justice Roberts' final section of the opinion. He says in SSFA, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race has affected his or her life, be it through discrimination, inspiration, or otherwise. And Chief Justice Roberts went on to explain that particular language did not give colleges and universities license to introduce, for example, an essay question on an application for the purpose of eliciting a student's racial or ethnic identity, but they could elicit information about a student's lived experience. So for example, if a student on an application discloses that they were the president of the Black Student Union in high school, a university could look at that piece of information and value it not because of the student's disclosure of their racial identity, but because that student has demonstrated leadership skills. And leadership skills are an indicator of success in a particular academic program. Similarly, if a student shares in an essay answer, for example, that they had overcome discrimination, a university can consider that piece of information not because it may share something about that student's racial or ethnic identity, but because that student has demonstrated an ability to overcome adversity, grit and tenacity, and an institution may value those particular characteristics because, for example, graduate students may run into obstacles in their research. And we want to know they're resilient, they're not going to crumble at the first sign of adversity, and so they have a demonstrated track record for overcoming those kinds of challenges. So the roadmap was in that final part of the decision, and colleges and universities took many steps to sort of implement that. Some actually used the language from Chief Justice Roberts' conclusion as an essay prompt in and of itself. Some pulled back from diversity statements altogether. At the University of Minnesota, the undergraduate application prior to the decision had an optional short answer question asking students how they would contribute to diversity at the University of Minnesota. A decision was made to make that question a required answer going forward, to sort of ask students to share that information going forward. Another decision that a lot of colleges and universities made following this decision had to do with the demographic checkbox. So back 100 years ago when I applied to college, it was on paper. On the first page of the application, I was asked an optional question where I could check a box and I could disclose my racial or ethnic background on that application. It's now electronic, but the checkbox is still there at the beginning of the application. Colleges and universities still ask the question. There are federal reporting requirements. There are a whole host of reasons why that information needs to be gathered. But a lot of institutions made a decision to mask that information. So basically, for anybody who's functioning in an admissions decision-making capacity, right? Anybody who has the ability to make it more or less likely that a student is admitted, that information, that demographic checkbox is unavailable to those decision makers. And that's for the express reason that the decision is pretty clear on its face that the Supreme Court does not believe that the fact of somebody's race or ethnicity in and of itself contributes to diversity. So that simple checkbox no longer has utility in a decision-making process, and a decision has been made by a lot of institutions to simply make that information unavailable to decision makers. There's been a lot of thinking too about who is a decision maker, right? Some programs may use an administrator to sort of cull the 500 applications down to 100 people so that the people doing more substantive decision making don't have to review all of them. There's often a committee that may review several layers of reviewers. At the University of Minnesota, we've tried to look at that term as liberally as possible. And so anybody who can make it more or less likely that someone would be admitted is functioning in a decision-making capacity and will not see that demographic checkbox. There's one exception there, and that's for students who disclose eligibility for membership in a federally recognized Indian tribe. There's a long line of Supreme Court cases that make clear that the eligibility for membership in a federally recognized tribe is not a racial or ethnic categorization, that's a recognition of the dual sovereignty of the Indian tribes. And because out of a respect for tribal sovereignty, we can still consider that particular eligibility in making decisions going forward. So that information, if a student self-discloses that eligibility, is available to decision makers. And then this has been coupled with a lot of training, right? Talking to people about what that lived experience means, right? Because it's undeniable that there will be a whole host of ways that people evaluating college applications are going to learn the race or ethnicity of an applicant, right? An applicant may self-disclose that information in a personal statement. The applicant may share some activities that they were involved in or affinity groups that may line up with a racial or ethnic identity. Folks may make an assumption about somebody based on their last name. We have programs, for example, we have conservatory programs where students audition. So they're physically present or there's an interview, and somebody in that setting may make an assumption about somebody's race or ethnicity based on their appearance. So there are a whole host of ways this information may become part of the decision-making process. So it's really important that decision makers understand how they can interact with that information, right? They cannot ascribe points to it or a plus factor based on that zero-sum structure that Jill talked about a little bit before. The Supreme Court sort of held that there are only so many seats in a college class. So if you preference some applicants based on their racial or ethnic identity, you're necessarily penalizing others for not having the desired racial or ethnic background. So because of that, it's important for folks to know that they need to look not to the racial or ethnic identity, but to the holistic student, right? To the whole student and what they individually bring to the table. Looking to lived experiences, looking to things that tie to experience rather than identity. So it's really looking at how those diversity statements, to the extent institutions have them, are framed on an application to elicit the kind of information that's most useful in review. Another thing that a lot of institutions are moving toward is the adoption of admissions rubrics, right? Sort of standardized instruments to evaluate admissions decision-making and to order thinking, right? Something that engages with a program, identifies what traits, attributes, and characteristics contribute to success in that program, and measuring those on a standardized instrument so that every applicant is measured against the same criteria and that those criteria can be reviewed going forward. Because we've already seen challenges, as Jill mentioned, West Point's already been sued. It's also possible for folks who are aggrieved by admissions processes to file complaints with the U.S. Department of Education's Office for Civil Rights, which is seeing complaints in this area as well. So having documentation in place to support the decisions that were made is more important than ever going forward. About 45 days after the decision, the Biden administration met its promise, and the Departments of Justice and Department of Education together issued a joint FAQ on how they were going to interpret the Supreme Court's decision going forward. That guidance made clear that it is okay and permissible for colleges and universities to do targeted recruiting to sort of look to do what you can to diversify the applicant pool, as long as when students are in the applicant pool, everybody has an equal opportunity regardless of race or ethnicity. That guidance also made clear that it's permissible for colleges and universities to have race-conscious support structures in place at colleges and universities, right? So affinity groups for students, tutoring, other supports, as long as those race-conscious supports are open to all students, regardless of race or ethnicity. So there's an awareness of consciousness, but there has to, if you want to have a program that has a preference for students that takes into account race or ethnicity, it has to meet that really high, strict scrutiny standard that's articulated in the SFAA decision. The one thing everybody, I think, was really hoping would be articulated in that guidance was some guidance on scholarships. Right. So in college admissions, certainly that admissions decision unlocks the door for a student, but many students can't actually turn the knob and pass through the door unless they have the means to afford the college education. So the scholarship can really be the component that brings the educational opportunity home for a student. The Biden administration was silent on scholarships and whether it would interpret the decision as applying to scholarships. That said, in the past, when there have been challenges that have come into scholarships that are race aware or that turn on gender, courts have regularly looked to the admissions cases for guidance on how to determine whether the decision applies to scholarships. So a lot of institutions are working through what their risk tolerance is with respect to the extent of the decision applying as well to scholarships. And I think the other thing we're finally dealing with, I think of this sort of as a two-phase process, right? We got the guidance in June. We still had a couple applicants who were coming through, but right now we're in the full throes of an admission cycle. Some students are just now getting early action decisions, and then decisions will be coming out all spring. So there's been one round where we engaged with admissions decision makers to give advice based on our best interpretation of the decision. Now we're in the phase where folks are having to actually implement that advice and make decisions using the new frameworks that we have put in place. And we're trying to sort of determine whether the advice we've given is operationalizable and how the actual decision-making processes are working. The other thing I think that is sort of in the back of our head from the decision is if you've looked through the decision, in the majority, about halfway through the decision, there's a chart on one page that sort of tracks Harvard's undergraduate classes' racial composition over time. And the numbers are relatively flat. So one year it would be 7% Black students, 7% Black students, 8%, 7% over time. And the court was very bothered by those statistics. The court said that the flatness of the statistics, the fact that Harvard was achieving pretty near year to year even levels of racial representation in its classes, suggested that Harvard was engaging in what the court called racial balancing, and that racial balancing is per se unconstitutional under the 14th Amendment. A lot of colleges and universities did what the University of Minnesota did after the decision came out and re-articulated their commitment to diversity. The real question, though, going forward is if numbers remain flat going forward, and the court's statement that flat numbers give a presumption of racial balancing, we're all sort of waiting to see going forward if that is an avenue for challenge, right? There's a couple ways to challenge an admissions decision. One person could individually raise their hand and say that they were harmed in an admission process, that they believe they individually were discriminated against on the basis of race. But then there's this other avenue of challenge of looking at class composition over time, right? And if the inability to consider race and ethnicity results in equally flat numbers going forward, that presumption could be held against colleges and universities going forward as an indicator of continued engagement in the practice that the court described as racial balancing. So we know about the military academy lawsuit, but we sort of don't know what challenges are coming next, both in the admissions sphere and then in ancillary spheres in higher education as well.
If I can interrupt for a second, there has been a follow-up question submitted on scholarships, which you've talked about a little, Carrie, but the specific question is whether the decision prevents separate nonprofit scholarship funds from giving scholarships on the basis of people of color. And kind of if either you, Carrie, or you, Jill, have any comments on that. The question asker talks about a nonprofit that raises funds for students of color to go to Minnesota State universities who have family members who belong to a union. So that's the context of from the question asker.
I can take a start at that one. So there are a couple of different kinds of scholarships available to students. There are scholarship funds that are held by an institution of higher education that, either have come from institutional funds and an institution deciding to establish a scholarship for a specific purpose, or a donor donating funds to the institution of higher education to establish a scholarship for a particular purpose. And then there are outside scholarships, right? Scholarships that are unaffiliated with a particular college or university, but that a private foundation, for example, may raise funds and establish a scholarship for a particular purpose. The decision on its face does not apply to those sort of separate 501c3 organizations. Those are not under Title VI institutions that accept federal funding like a college or university does. Certainly when the money comes into a college or university, the college or university has to administer that money in a way that is consistent with its obligations under the Constitution and under federal civil rights law. But outside entities have to sort of comply with the laws that apply to them. So this decision would not have an application to a private or a separate foundation that lives outside of a college or university.
I can also say, so I think that's right. This decision doesn't reach that. The only, I think, thing I would add is that the people who are behind SFAA, led by a guy named Ed Baum, are fully committed, I think, to litigating to the ends of the earth. And there are a series of cases suggesting that discrimination can jeopardize a nonprofit's nonprofit status. I'm particularly thinking about Bob Jones University, which had a different point. Like first they banned Black students, then I think they had a rule against interracial dating, and eventually there was trouble with the IRS about maintaining their nonprofit status. So I don't think that that's tomorrow, but I could imagine a world in which, because what's the thesis of SFA? Affirmative action, meaning giving a boost or making an opportunity available only to race, is race discrimination, full stop. Eventually, I suspect that there will be some efforts to go after private, nonprofit scholarships if they're race limited. That's not this opinion, but the logic of this opinion to me suggests that they're more vulnerable than they were before SFA was decided, certainly.
There is another question that has been submitted asking, what implications does this decision have, if any, for other historically marginalized classifications like gender, including non-binary genders, sexual orientation, immigration status, first-generation students, etc.?
Okay, so one of the ironies of equal protection law is that race-based discrimination was subject to strict scrutiny, and a lot of other groups have spent a long time trying to get strict scrutiny for their groups. Like, for instance, Ruth Bader Ginsburg, when she was a feminist litigator, tried to get strict scrutiny applied to sex-based classifications. One of the ironies of SFA is that sometimes it's good not to have strict scrutiny. So I think there are arguments that white women have been the primary beneficiaries of affirmative action in terms of numbers, but the court doesn't apply strict scrutiny to sex-based classifications. It applies intermediate scrutiny. And more to the point, the court really hasn't been interested in challenges to sex-based affirmative action, so we don't know what they think. But this opinion is specifically about race. I'll also say another thing that's interesting about sex-based affirmative action is the evidence suggests that men are the current beneficiaries of sex-based affirmative action because women do better in high school. But, fancy colleges think that their status will go around if they have too many women. So they cap it. Like, women might get to 51 or 52%, but that's it. They're not letting them get to 55%. There's definitely affirmative action for men. But to date, the court hasn't been interested in that. And this opinion really would not apply because strict scrutiny doesn't apply to sex-based distinctions.
The next question submitted asks, if flat numbers show racial balancing, Do rising racial minority numbers establish that white students are being harmed using the Supreme Court's reasoning?
I mean, I think if the only thing a court is looking at is numbers, then the analysis isn't sound, right? So, I mean, the numbers were one thing that the court looked at in this case, but the court also looked at notes of admissions officers. There was actually some pretty embarrassing evidence for Harvard at the trial court level in this case, where some notes that admissions officers had would they had a personal score for Harvard students, and some of them would sort of include very stereotypical comments about students tied to their racial or ethnic identity. I think to sort of combat the presumption in that question, that's why that documentation I mentioned, I think, is really important going forward, that there needs to be some way for, if a challenge comes in, that a college or university can demonstrate that it really has holistically reviewed each individual student based on everything that that student brings to the table. Because the court does not reject the idea of diversity as a value that's important to colleges and universities in the opinion. What it rejects is the presumption that somebody's race or ethnicity contributes to diversity. It sort of doesn't really sit well with the idea of representational diversity. It's really looking at diversity as the viewpoints and points of view that are brought into a classroom for engagement and discussion. And to suggest that somebody's racial or ethnic identity contributes to that makes a stereotypical presumption that everybody of a particular identity shares a viewpoint. So I think that if colleges and universities have documentation that shows they're engaging in that holistic review and really is tying the indicators of success in a program to what they're reviewing students for, then the numbers will become less important if a challenge comes in.
I also think that in some way, I think rising numbers what I think the court really focused on was the invariability of the numbers, that no matter what Harvard said, it was like the same numbers over and over again, suggesting that they had an internal metric of what they were trying to, it wasn't as individualized as they claimed. So that to me, that's what I think. I agree with Carrie that the numbers aren't everything, but I think that was the bad part of the numbers. It was just the same numbers over and over again, suggesting that Harvard did have an internal target that it was hitting year after year. And so whatever they were saying, it was not consistent with what they were actually doing. The other thing I just want to say about the essay, first, I think that the whole discussion of you can write this essay about your own personal experiences, I think is a good example of what a difference a dissent can make. I think one reason that was included, I'm not sure if it would have been included otherwise, is that Justice Jackson, who knows, of course, she's going to lose, she's going to be on the losing side of this case. She asked the lawyers challenging affirmative action, she says, someone who went to UNC and is a seventh generation legacy, they definitely can tell that story. Why can't someone tell the story of their family that's about why my family didn't go to UNC? Like we were enslaved and then Jim Crow, we were excluded, all the things. And the lawyer said back, no, you can tell that story. You can tell the story of your own life. And I think that's why Roberts basically decided to add it. It's not clear to me he would have added it before, but even as he's saying it, he says, if this becomes a workaround for affirmative action, we're not gonna tolerate it. And one irony, of course, is Ed Baum, the guy behind these suits. The last thing he wants is more essays. He hates essays. He hates anything he considers fun. He just wants it to be grades and GPA. So ironies abound. So I think it is going to be interesting with the essays because they definitely are ubiquitous now. I think every university almost has these essays. I suspect, just again on the idea this is going to be fully litigated, there will be lawsuits arguing that these essays are just a workaround to try to get people's racial identity. And then the numbers will be relevant to that. Do the numbers ever vary, or are they just the same all the time?
And to the point about workarounds, I think the other thing that we're also watching with interest is there is a case in Virginia surrounding a magnet high school for science and technology called Thomas Jefferson. And that high school had noticed that over time, they were seeing higher numbers of white and Asian American students and really dropping numbers of Black and Latino students. So that high school decided to adopt race-neutral criteria to try to diversify its student body. So for example, it eliminated a standardized test. It set aside a top 10% plan for all of the middle schools that were feeding into the high school. And so these were all things, and it looked at particular zip codes in the area as well. So things, none of which actually reference or are dependent on race. And over the course of several years, they saw a real increase in Black and Latino students and more racial diversity in the high school. And a group of parents banded together called Coalition for TJ and sued and contended that these race-neutral criteria, because they were adopted for the sole purpose of diversifying the student body, violated the Constitution. And they prevailed at the trial court level before the case was reversed by the Fourth Circuit. But that's another sort of angle on these challenges as well, right? Is sort of core institutions trying to really adopt facially neutral criteria, but having those challenged because of a disparate impact on the back end.
Yeah, I think that's the future. There's going to be just challenges to facially neutral policy. So the suit against Thomas Jefferson Magnet School is like a suit from the right. There's also, I think, been some efforts from the left. After the Harvard case came down, which gives us all this juicy insider information about Harvard, a group of civil rights organizations filed a complaint with the Department of Education saying that Harvard's legacy preference is a violation because it disproportionately helps wealthy and white students. So in some ways, it's not surprising that there's going to be so many suits about facially neutral policies, because that's all that's going to be left. There's no more policies that explicitly take race into account. Of course, there's going to be endless challenges about facially neutral policies. Similarly, right now, the court doesn't apply any constitutional scrutiny to wealth-based classifications, which from the left had been a disappointment because there's all these policies that disproportionately impact the poor, et cetera, et cetera. But in the affirmative action context, it means that, say, privileging, giving a boost to first-generation students, which is basically like a class-based boost, shouldn't trigger any real scrutiny under the Constitution. But I suspect there's going to be a lot of litigation eventually about that. That is essentially, they're going to say, a workaround for affirmative action, and this is another way. That's what motivated it. And we'll see how far the court's willing to go.
In the final few minutes, there are several pending questions asking about the implication of the decision in for private or public employers. So you mentioned, Professor Hasday, Title VII context. And the questions, if I can kind of weave them all together, generally ask, what are the implications of the decision for employers who want to address a lack of diversity in the workplace? And also wondering about diversity, equity, and inclusion programs in non-university and college settings. So how does the decision impact, if at all? Well,
this decision is just about Title VII and Title VI, which is receiving federal funds. So your average private employer isn't directly impacted. But if you want to, what's the thesis statement of SFAA? It's that affirmative action that gives a boost to someone for being a member of an underrepresented racial or ethnic group is race discrimination, full stop. That's the opinion. So I think it's very unlikely that private employers would be able to get away with that in the Title VII context. I think the court is very likely to say that that's race discrimination under Title VII. That said, I think saying you couldn't have a program designed to promote diversity, that's several steps away from where the court is now. The court just hasn't gotten there yet, and we'll see if they're willing to go, if we're willing to go that far.
And the next question asks about whether could a university or another entity have an affirmative defense against numbers that may show favoritism of a particular protected class if they can also present numbers that show positive impact, such as low-income students, which I know is something that's been touched on. I don't
think I totally understand that question, and that's probably my fault. But right, I mean, I for fear of repeating myself, right, I do think the numbers are just one component. And so I do think if demonstrably other factors are considered, I mean, certainly if you can go to any college, any competitive college or university's admissions website, and they will tell you the context factors that they consider. Most that engage in holistic review look at GPA and test scores and the competitiveness of the high school program, but then they also will list a whole host of other factors, extracurricular activities, socioeconomic status. and sort of attempt to sort of have that net be as broad as possible in terms of considering the different kinds of diversity that students can contribute.
As a final question, I think this is directed to Carrie. Are there any themes or differences in how schools, universities are responding, or is everyone's response fairly consistent with the advice that's being given by the Biden administration and other things?
In my conversations, I think that the response has been relatively consistent, right? I think there's been a lot of re-articulation by many institutions of their commitment to diversity. There's a real fear in communicating to students, right? That I think colleges and universities don't want students to hear the message that higher education doesn't care about a diverse student body, right? And that's, I think, sometimes how this decision can land. So a lot of institutions have been taking steps to re-articulate their commitment to diversity. I think with the essay questions introduced is, in a way to signal to students that institutions are interested in eliciting information about the different ways a student will contribute to student body. And then I think we'll see going forward, like I said, a lot of institutions made that decision to mask the demographic checkbox. For the reasons I mentioned, that there's going to be so many other ways to learn a student's racial or ethnic identity. I don't know how powerful a tool that really is in influencing decision making. So I think we'll see going forward whether institutions, back off from that decision, make different decisions going forward. But I've seen generally that's been sort of the universe of responses that I've seen.
Well, with that, we've hit our time. I want to thank Professor Hasday and Carrie for their very in-depth discussion of these issues and for their excellent answers to our questions. I want to thank the Board of Advisors and the committee for putting together this great panel. We're looking forward to more CLEs later in the academic year, continuing excellent conversations to bring forth the wealth of expertise and knowledge at the University of Minnesota Law School, at the University of Minnesota writ large. Thank you to my co-member of the board, Emerald, for her excellent refereeing of this discussion. And we look forward to seeing folks down the line at the University of Minnesota Law School. Take care.